Good morning, good afternoon, and good evening, depending on your time zone. Welcome to the 2025 Climate Law and Governance Day. My name is Tejas Rao, and as Senior Manager of the Center for International Sustainable Development Law, which serves as the Secretariat to the Climate Law and Governance Initiative, I will be one of your moderators over the course of the day.
Hello, everyone, and thank you for joining us. My name is Christian Diaz-Ordonez, and I'm a researcher at the University of Cambridge and an associate fellow at the Center for International Sustainable Development Law. I will also be one of your moderators over the course of the day.
Bom dia and warmest of welcomes from me as well. I am Rayla Puno. As one of the coordinators for the Center for International Sustainable Development Law, I will serve as a moderator of the 2025 Climate Law and Governance Day. It is my distinct pleasure to introduce our Master of Ceremonies and Lead Rapporteur, Advocate Ayman Shakawi, is Director at the Hassan II International Center for Environmental Training and Coordinator of the Muhammad VI Prize for the Climate and Sustainable Development in Morocco, and is joining us from COP30 in Belem. He also serves as lead counsel for climate change in the Center for International Sustainable Development Law, among many other distinguished international leadership positions in international policy, law, and action, and has kindly guided us through nearly a decade of CLGD. Advocate Himanshu Pabreja is CLGI Coordinator and Associate Fellow for CISDL. An India-qualified lawyer, he also serves as a researcher in the LSE Grantham Research Institute and University College London, and leader of several youth organizations, including Legal Voices for the Future. Dr. Jelly Molino is a research by-fellow, Hughes Hall at the University of Cambridge, and a world-renowned international legal expert on sustainable public procurement. A member of the Philippine Bar and experienced consultant with many leading international organizations, she presently serves as international expert for the World Bank in Bangladesh. She will be directing our rapporteurs to develop the proceedings report for the day.
Advocate
Good morning.
Good morning. Sorry.
Yeah. Thank you. Good morning, good afternoon, good evening. Wherever you are in the world, thank you. Thank you so much for joining us for the 2025 Climate Law and Governance Day. As lead counsel for the CISDL Climate Law Program, it is a pleasure to return to this event year after year after year and see how far and wide the community of climate lawyers and policymakers has grown. This convening power, the ability to bring together diverse perspectives and expertise, has rarely been as crucial as it is today. As we face the mounting challenges of our climate crisis, it is through these connections, these exchanges of knowledge and experiences, that we forge the pathways to meaningful action when it comes to the planet, the people, and peace. Thank you.
Thank you, Advocate Ayman. It is truly a pleasure to have each of you with us, and we are thrilled to welcome over 3,200 people who have registered from over 110 countries for this full-day symposium. So welcome to all. Today's program reflects the depth and breadth of our community's expertise, and from operationalizing the Paris Agreement at 10 in the first decade at 10 to scaling up the national climate ambitions and action through law and governance, from advancing climate justice to deploying innovative legal instruments to invest in just transition. These are some of the key cutting-edge issues of climate law and governance that we will be exploring throughout the day. And I'll just pass over to Dr. Jelly.
Good morning and good afternoon, good evening. I am deeply honored to be joining you as the lead rapporteur of the Climate Law and Governance Initiative, guiding the moderators and rapporteurs who join each of your sessions. I will be collaborating with you to prepare the report from the day, not just conveying the flavor of the rich and insightful dialogues, but also highlighting the new partnerships, project, and potentially law and policy reforms that sparked or strengthened through the day.
Advocate Ayman. Thank you very much, Jelly. And thank you also to everyone who has joined us here in this marvelous event. I will turn now to the Master of Ceremonies, Ayman Shirkawi, and the other Master of Ceremonies, Himanshu Reja. I have been invited by some of our colleagues who are differently able to give brief physical descriptions of those who have joined us today. So I will just point out that Advocate Ayman has very short hair and is joining us from Belem. He's in a full suit and has a large Moroccan smile on his face. And Advocate Himanshu has a beard and glasses and dark short hair as well. And he is joining us from Rio. And I will invite you to help us to launch the day by introducing your two chairs. And I'm hoping that Ayman has received the script for this morning, but if not, I will invite Himanshu to step in.
Thank you so much, Professor Marie-Claire. I'll start introducing the chairs for the first session, which is grand opening. Professor Dr. Marie-Claire Cordonier Segger is a highly distinguished international scholar and jurist and holds the chair in Sustainable Development Law and Policy at the University of Cambridge. As the CISDL Senior Director, she's also a CLGI Executive Secretary and since its founding in COP11 in 2005. She's also served as a Senior Legal Advisor to the UNEP CCC Presidency and advised various climate vulnerable countries over the years. With international law degrees from both Oxford and Cambridge, she has published over 26 books and over 170 papers in 5 languages. So it's an honor for Professor Marie-Claire to be with us here. Our second chair is Professor Dr. Gelson Leonardo Rech. He is a distinguished Brazilian jurist, Rector of Universidade de Caxias do Sul in Brazil, which is one of our leading local courts. He has a PhD in education and a background in philosophy of education and ethics. His research spans epistemology, the history of education, particularly Italian immigrant schooling in southern Brazil, and institutional leadership in higher education. He has served in multiple senior management roles and is renowned for bridging rigorous scholarship with strategic governance in educational context. He is joining us from Rio Grande do Sul with Professor Leonardo de Camargo Satil, the founder and president of the Brazilian Institute for the Law of the Sea, who has also served as a Nippon Fellow and a researcher at the ITLOS in Hamburg, Germany. He has published over 80 books, over 8 books in this field. He has served as a coordinator of the UCS PhD and Masters in Environmental Law. With such distinguished chairs and colleagues, we are truly in good hands for this opening and for the day. Professor Cordonier Segger and Professor Rech, the floor is yours.
Thank you very much. And warmest of welcomes to Climate Law and Governance Day 2025. In these increasingly troubled times, humanity faces serious challenges of intensifying conflict, poverty and economic instability, human rights violations, and ecological degradation, the shattering of planetary boundaries, especially due to global climate change. The law can be seen as a sword or shield, but right now it is also an hourglass, with our time to secure climate justice running out so fast. In the face of current headwinds, our ambition, our contributions, and frankly, our resolve must scale up faster than ever. In this context, we gather online during the United Nations Conference of the Parties number 30 in Belem and Rio across the Americas and worldwide for one of the largest climate law and governance days yet, with over 3,300 registrants from more than 110 countries. Since we began meeting as jurists and public policy leaders at COP11 2005 at McGill Law Faculty in Montreal, and since we adopted implementation of the Paris Agreement as our shared mandate at the Sorbonne during COP21 in 2015 in Paris, our Climate Law and Governance Day Program Committee has been convening the expertise, the experience, and the innovation needed to strengthen the legal and institutional architecture for climate action and to galvanize the law and policy community. Through our conversations this year, we will explore the implications of recent legal developments, including some highly significant advisory opinions from international courts and tribunals. We will share climate law and public policy experiences worldwide, and we will forge the partnerships that are needed to accelerate implementation of the Paris Agreement. As always, the Climate Law and Governance Initiative is especially delighted to partner with leading law faculties of our presidency host country, and we deeply appreciate the hospitality of the Universidad do Caxias do Sul of Rio Grande do Sul. Also, the UFPA, the Universidad Federal de Pará de las Amazonas of Belem, and the Fundación Julio Vargas of Rio de Janeiro here in Brazil. I will now turn to my co-chair, Professor Gelson, for his words of welcome.
Thank you, Professor. Good morning, good afternoon, and good evening, everyone. It's a pleasure to be here with you. I wish to extend a warm greeting to Brazil in its role as president of COP30, to the honorable judges, professors, students, attorneys, practitioners, and members of international and civil society organizations in support of climate laws, policies, and practices aimed at reducing greenhouse gas emissions. Extending a warm greeting to dear Professor Marie-Claire Segger, I also wish to convey my regards to all other partners, individuals, and institutions involved in this remarkable event, Climate Law and Governance Day 2025, organized by Center for International Sustainable Development Law during COP30. Moreover, our university, UCS, Universidade de Caxias do Sul, will participate in the Climate Law and Governance Specialization course on 16th November. The University of Caxias do Sul is honored to be among the hosting institutions alongside the Federal University of Pará, the University of Cambridge, and FGV Law at the world's largest legal event held during COP30. We are a university located in southern Brazil, based in Caxias do Sul, a city, near Porto Alegre, capital, and 3 hours from the Atlantic Ocean, with over 20,000 students and a long-standing tradition of research and innovation. Our vibrant region blends 150 years of Italian immigration to Brazil with Gaúcho traditions from the Pampa, offering stunning landscapes and delicious culinary. Since 1967, we have graduated 133,000 students across 8 cities in our region. We are ranked 60 in research among private and community universities in Brazilian rankings. UCS is very grateful to be part of such initiative. We are part of the Sustainable Development Solutions Network, one of the world's largest networks advocating for the Sustainable Development Goals. Moreover, our strategic planning and action programs are aimed at achieving the UN Sustainable Development Goals and mitigating the devastating impacts of climate change. In 2024, the state of Rio Grande do Sul, where we are based, experienced extreme rainfall that caused the worst flooding in the southern Brazil, affecting 2.3 million people, resulting in 183 deaths and an economic impact of $15 billion. Combining climate change, irregular settlement, and inadequate infrastructure, the 2024 floods underscore the urgent need for immediate global action. One of these actions considers the role that climate law plays in identified solutions and preventing new disasters, emphasizing the importance of Climate Law and Governance Day 2025, an event that examines the climate phenomenon at both the local and global levels. Our University of Caxias do Sul also wishes to thank Professor Alessandra Lemen and Leonardo de Camargo Subtil by my side, both from our postgrad program in law, the first in environmental law in Brazil. It's a pleasure. For connecting us and representing us at this significant event for a world that urgently needs answer, including from the law. It's an honor to help chair this gathering today on behalf of my university and my country. Thank you very much, Professor and other participants.
Thank you very much as well, Professor Gelson, and thank you especially for the engagement and encouragement and indeed sheerly fascinating involvement of your professors and students from your faculty in this process over the months that we have been collaborating. It is truly our honor to be with you here in Brazil and to be hosted by your faculty and by your country.
Thank you.
I'd also like to thank Professors Alessandra and Leonardo, especially for their assistance. We are deeply grateful for this hospitality, and we look forward to this day and to future collaborations. We're now especially delighted to turn to several highly respected leaders from the global climate law and governance community to welcome each of you on behalf of key partner institutions. It is a grand pleasure to introduce them to you now. First, we are very, very pleased to be joined by Professor Kameri-Mbote, Director of the Law Division at the United Nations Environment Programme. She is a world-recognized authority in environmental law and policy with over 2 decades of international experience and a laureate of Climate Law and Governance Global Leadership Award. Former Dean of the School of Law at the University of Nairobi and a governor of the International Council on Environmental Law since 2007, she has shaped international legal frameworks through research, negotiation, and senior advisory roles with expert credentials spanning the Universities of Stanford, Zimbabwe, and Nairobi, as well as honorary doctorate, probably not the first one that she will receive, or not the last one, from the University of Oslo. She is, of course, joining us from the United Nations Environment Programme in Nairobi with dark hair and glasses and a gray jacket and a beautiful necklace of Africa on her neck. So, and a very, very big smile. Professor Astrid Puentes Riaño is also here with us. She is, of course, the United Nations Special Rapporteur on the human right to a clean, healthy, and sustainable environment, and a professor at the Universidad Iberoamericana of Mexico, as well as a leading expert in environmental law and climate justice across all of the Americas, having served for nearly 2 decades as co-executive director of the Inter-American Association for Environmental Defense, AIDA, where she led landmark regional litigation on human rights and the environment. Her highly distinguished leadership bridges policy, law, and community-centered advocacy with a strong focus on the protection of Indigenous peoples and other groups affected by environmental harm. And again, for those differently abled who are joining us today, she has dark hair, beautiful red earrings that are nearly sort of a scarlet pink, along with a jacket that is a lovely cream and ivory color, and a very lovely smile as well. So we are very, very happy to have her with us. Advocate Mike Strauss is General Counsel of the European Bank for Reconstruction and Development and laureate of the only once given twice Climate Law and Governance Global Leadership Award, which he won with his team just 2 years ago in Dubai. He's a leading voice in international discussions on climate finance, a member of the Executive Committee and Crisis Management Team at EBRD, and also has represented the US on the board of the Asian Development Bank, building key experience from his roles in the World Bank Group and in the IMF. And he is an extremely distinguished-looking gentleman with dark glasses, dark-rimmed glasses, short hair, an extremely nice but quite firm smile, and a dark blue jumper and suit jacket, I think joining us from Paris. We are also very, very honored to be joined by Professor Damilola Olawuyi, Vice Chair of the International Law Association that has been part of this community since the very start, and UNESCO Chair in Environmental Law and Sustainable Development at HBKU, Hamad bin Khalifa University in Doha. He's a renowned international lawyer, professor of law, arbitrator, author, public policy consultant, and indeed also a very dear friend. And together we chair the ILA Committee for International Law and SDGs. He serves as Deputy Vice Chancellor, Chancellor's Fellow, and Director of the OGIS in a leading Nigerian university, having founded one of the world's first sustainable development law journals. And he also leads the work of the International Bar Association in human rights law and business. And for those of you who wish, we have him also in a very charming pink tie and a full dark blue business suit and a broad smile and short dark hair joining us, I think, from Doha, but on a different time zone because he just came back from Toronto. We are joined as well by Professor Rashad Ibadov, who is founding dean of the School of Law of ADA University in Baku, Azerbaijan, and a visiting professor of law at the Catholic University of Lille in France. As founding dean, Professor Rashad has transformed the teaching of law in Azerbaijan through the first law degree offered in the English language in the country. And he is, of course, well known to all of us as the local host of Climate Law and Governance Day 2024 during COP29 in Baku. He has continued with his leadership as a member, honored member of our program committee. And he is with short curly hair, a very wide smile, and a beautiful business suit and a dark blue tie joining us, I think, from Baku. Finally, we are joined as well by Professor Paula da Cunha Duarte, who is coordinator of the Research Collective on Advanced Studies in Regulation of the Brazilian Financial System at FGV, Fundación Julio Vargas, Rio Law, a distinguished visiting researcher at the Berlin School of Economics and Law, where she's an associate member of the Institute of Economic Policy, and leading research with the FGV's Center for Research in Economics and Law. She was one of the chairs for A Mandate for All, the legal and civic imperative to confront the climate emergency, a brilliant international pre-conference which took place this week in Rio, Belem, and New York, co-hosted by FGV Law and PACE, in which the Climate Law and Governance Initiative was honored to be a partner. So she is joining us as well from Rio with dark-rimmed glasses, beautiful long chestnut hair, and a big smile. Imagine many people smiling at you, and you will have more or less the picture of our panel today. I'm going to turn to Professor Patricia, who is going to address the plenary and welcome us to the day. Professor Patricia, the floor is yours.
Thank you very much, Professor Cordonier Segger. It is indeed my great privilege to be joining you here, and I'm looking forward to this year's Climate Law and Governance Day. On behalf of the United Nations Environment Programme, it is a pleasure to partner on the 2025 Climate Law and Governance Day. We are honored to support this important event once again, and I am delighted to join you both as the director of UNEP's Law Division, as well as a member of the Climate Law and Governance Initiative Program Committee. We are really at a pivotal time for environmental multilateralism. COP30 lifted off just last week with significant initiatives and pledges around the protection of forests. In less than 1 month, the United Nations Environment Assembly, which is the highest decision-making body on the environment, will take place here in Nairobi, and nations will gather to recommit to the environmental agenda and address emerging environmental challenges. Around the world, the role of law in responding to the climate crisis has never been more vital. Law provides the foundation for ambition, accountability, and justice. Across all regions, UNEP is working hand in hand with member states to strengthen the environmental rule of law, helping countries to design, implement, and enforce robust climate laws and policies, update their nationally determined contributions, and integrate climate considerations into constitutions, planning frameworks, and judicial systems. Through our Framework Environmental Law Program, the Montevideo Environmental Law Program, and other initiatives, we work with governments, judges, and legal professionals to translate global commitments into effective national actions. In particular, UNEP is supporting states to build capacity of key justice actors, including judges, lawyers, prosecutors, to name a few. We are also advancing rights-based approaches and fostering fairness, inclusivity, and evidence-based decision-making. Together with the Climate Law and Governance Initiative, we celebrate your dedication to innovation, partnership, and justice. May the dialogues and collaborations we begin today inspire stronger, more coherent, and courageous legal and institutional pathways toward a climate resilient and sustainable future for all. I am especially looking forward to our next session. Thank you.
Thank you so much, Professor Patricia. And I am also looking forward to our next session. Who would have believed we would be here a year ago? And now we are. Professor Astrid, please, the floor is yours.
Bon dia, everyone. It's really a pleasure for me to be here and joining all of you. And thank you very much for the invitation. And congratulations also to the University of Cambridge and the Fundación Getúlio Vargas, the Universidade dos Caxias do Sul, and the Universidade Federal do Pará for organizing this very exciting Climate Law and Governance Day. Today, as we think about the Paris Agreement and this decade that has passed and how to advance climate courage, contributions and compliance, I want to reflect mainly about where we are, opportunities, and specifically highlight the important role that we have as lawyers and law practitioners, researchers, to help to advance climate action today. So first, a little bit reminder of where we are. Of course, we know that emissions continue rising, not as a pace as they were, especially 10 years ago. We have seen that, fortunately, the global temperature is now planning to be raised between 2.5 or 2.9 degrees Celsius, which is not ideal, and it will include a lot of impacts, but it has decreased significantly from the about 4 degrees that was planned or projected to be raised before the Paris Agreement. So of course, there's very positive, still challenges, but very positive advances that we have to highlight. Of course, we have also gaps. We heard from the UNEP emissions gap report that although the new NDCs have advanced, they have barely moved, as they described, from where they were. We are in the verge of going above the 1.5 maximum limit that the science has identified. But at the same time, it's important to see that although in the Paris Agreement, there was the objective or the commitment to reduce as much as possible temperatures, and below 2 was the limit. Today, we see that at least the scientific limit of 1.5 is the most quoted and the limit that we should be looking at. Damages, of course, has increased, including heat, coral bleaching, hurricanes, the typhoons that we're seeing, which is and should be a call for action. Solutions have advanced, increasing, including coal phase out or phasing out from coal and many other solutions that you have seen. So I wanted to highlight three main advances in this decade that also shows how law has helped to advance and move us towards climate solution, but also the importance for implementation. The first thing, of course, is that in this decade, we have seen litigation increased in all corners, not because of the Paris Agreement, as some people would say, but because of the slow pace of solutions. And this litigation has helped us to clarify obligations. And today, of course, we have specifically this year, the 3 advisory opinions from the International Court of Justice, from IDLOS, and the Inter-American Court for Human Rights that help us specifically understand that there are key obligations of states to protect the environment, including the climate system, and to avoid environmental harms, which are key and are obligations that are erga omnes, which is a very important and a strong element that the ICJ helped us to clarify. The second element, of course, is the recognition by the UN of the human right to a clean, healthy, and sustainable environment, a recognition that took 5 decades and that many of us worked to achieve, and that, of course, the ICJ also and very strongly recognizes that the human right to a healthy environment is a precondition, is inherent, essential, and interdependent for the effective enjoyment of all human rights, and that it's key for states to fulfill their obligations to guarantee human rights. So given the practice and the opinion juries, some of us, and definitely I include, that we can already talk about the right to healthy environment as customary international law. So hopefully in the next decade or less, we will have a specific recognition about that too. Then, of course, the other is the increased recognition in this decade of the importance that we talk about inequality on climate, because it is, as we know, and we have seen already the IPCC, UN entities, and many others recognizes that we recognizing that when we talk about climate, we also talk about climate justice, and we have to tackle that inequality. So this led me about what are the opportunities, of course, that we have. Implementing advisory opinions, implementing international law that we have today, including decisions, not only in the advisory opinions, but with litigation cases, is absolutely key for including and making sure, hopefully, that the states and businesses recognize and implement their obligations. I want to end with highlighting that, of course, while there is a discussion about whether advisory opinions are binding or not, or their nature, we should move from that conversation and make sure that the obligations there, that the conclusions from courts are implemented in the ground. And highlighting, and this is something that I want to end today with, the important role that law has, especially today, as, for example, the court for the first time recognized the imperative of and the importance of climate information and the integrity of climate information. That, of course, as lawyers, we know that information is a human right, which means that it's an obligation for states, but also businesses. So I want to highlight this and end with, again, congratulating and knowing that climate is not only a technical issue, it also is a human rights issue. It has to do with law, and we need to advance the rule of law, avoid deregulation that unfortunately we're seeing globally, and make sure that our role is well understood and that we can work with states and with businesses and UN entities to make sure that climate justice is a reality. Thank you very much.
Thank you so much, Professor Astrid, and thanks especially for underlining, which I think will be key for our next session, that while advisory opinions are not meant to be new law, They will identify the binding law and explain it to us. And we should be able to picture that in our minds and to indeed ensure that it is actually understood worldwide. Deeply, deeply appreciated and directly relevant for this entire D. I'm now going to turn to Advocate Mike Strauss, a dear friend and colleague, and also extremely distinguished, charming Blue Brazier. Go ahead, please, Mike. The floor is yours.
Good morning to those joining from Brazil. Good afternoon to all colleagues connecting from Europe and Africa, and good evening to those connecting in Asia. On behalf of the European Bank for Reconstruction and Development, it's a great honor to open this year's Climate Law and Governance Day at COP30. Let me begin by extending my sincere thanks to Professor Marie-Claire and the entire CLGT team for their remarkable leadership and dedication. They have once again succeeded in bringing together leading voices from governments, multilateral institutions, academia, and the private sector to exchange ideas and strengthen the legal foundations of the climate transition. The EBRD is proud to be a continuous supporter of CLGT. For years, this platform has provided a unique space for the legal community, from regulators and judges to general counsels and academics, to exchange ideas on how law and legal professionals can turn climate commitments into concrete results. After all, the transition to a net zero and climate resilient economy is not just an economic or technological change, it's a legal one. It requires clear rules, predictable frameworks, enforceable obligations, and above all, trust in institutions. As Professor Patricia said, we meet at an historic moment. Nearly 10 years have passed since the adoption of the Paris Agreement, and the world is taking stock not only of our progress, but of the credibility and the durability of our collective response. In this next phase, our task is not only to finance and innovate, but to govern and implement, to build the laws, policies, and institutions that turn ambition into reality. The Brazilian COP30 presidency has captured this challenge beautifully through its call for a global mutirão, a community effort, a coming together for the common good. For us as multilateral development banks, this idea resonates deeply. It reflects how we work, pooling resources, knowledge, and legal frameworks to deliver transformation that no single institution could achieve alone. At the heart of this mutirão is a recognition that climate action is a shared responsibility, and that law is the glue that binds us together in that responsibility. This year's COP marks a turning point in how the international community views the role of law in climate governance. Around the world, we are witnessing a shift from voluntary commitments to enforceable obligations, from policy aspirations to legal accountability. The Paris Agreement gave us the framework. Now the challenge is to give it force through domestic legislation, climate-related financial regulation, and international cooperation. Multilateral development banks have a unique role to play here. By integrating legal reform, institutional strengthening, and financing, we help turn global principles into realities, ensuring that markets reward sustainable behavior and that the transition is both just and durable. As we stand at the crossroads of the Paris decade, this convergence of law, finance, and governance is what will determine whether we achieve the transition at scale and at speed. For the EBRD, law and governance have always been the connective tissue of sustainable development. From our origins after the Cold War, our current role as a global leader in green finance, we have learned that markets alone cannot drive transformation. It is the legal and institutional scaffolding that sustains it. Strong governance creates trust. Predictable frameworks attract capital. Clear and enforceable rules ensure that growth is both inclusive and sustainable. That's why we invest not only in projects, but also in laws, institutions, and capacity building, because the success of every solar farm, every climate bond, and every adaptation initiative depends on the functioning legal ecosystem that supports it. And as we begin today's discussion, I invite all of us to think about what the next 10 years will require from us as lawyers, as policymakers, and as institutions. We will need stronger laws, clearer standards, and deeper cooperation between public and private sectors. We will need to integrate nature alongside climate in our regulatory frameworks to ensure that adaptation and biodiversity protection go hand in hand. And above all, we must ensure that justice and fairness remain at the heart of the transition. So in the spirit of the mutirão, let us use this day to renew our shared commitment, to collaborate across borders and disciplines, to link finance and law, ambition and implementation, and to ensure that the decade ahead delivers real, inclusive, and legally grounded transformation. Thank you, and I wish you all a productive and inspiring Climate Law and Governance Day.
Warmest of thanks, Advocate Mike Strauss. I know that you are a dearly revered professor also when you are teaching in Stanford University, and I'm starting to see why That was an excellent address, and it is deeply appreciated. And we have so much honored your collaboration throughout the years, truly, in the D. I'll turn now to Professor Damilola, who is joining us online from Doha.
Thank you very much, Excellencies, dear friends and colleagues. It's indeed my great pleasure to be invited to address this year's Climate Law and Governance Day, a powerful annual collaborative event that brings together bar associations, international lawyers, and development organizations to exchange best practices and resources on climate law and governance. I congratulate Professor Segger and the entire Secretariat of the CLGD for expanding and sustaining this legacy. As SDG 17 reminds us, international solidarity and multi-stakeholder collaboration is required to advance all the SDGs, including SDG 13 on climate change. And of course, international law and governance associations have key roles to play in fostering such solidarity. And I'm glad that today, all leading international associations are represented, especially the International Law Association, ILA, the International Bar Association, IBA, and the Association of Environmental Law Lecturers in Middle East and North African Universities, ASELMU. And as a key stakeholder in all these associations, I have the singular honor, and I will say huge responsibility, to welcome you on behalf of all of them. First, as you may already know, the International Law Association has since 1873 provided a platform for the study, clarification, and development of international law, including climate change. And as Global Vice Chair and Co-Chair of the ILA Committee on SDGs, with Professor Cordonier Segger, of course, I do hope you will join us and contribute your insights on how international law can support current efforts to advance climate governance. Second, as chair of the International Bar Association's Academic Advisory Group, I wish to emphasize the critical role that the IBA plays in providing resources for legal practitioners to develop the skills and knowledge to advance climate action. The IBA, as the global voice of the legal profession, takes this role very seriously. Our Bar Issues Commission recently launched a climate change working group, which will undertake a wide range of activities to support bar associations across the world. We also have a wide range of capacity building activities around the UNFCCC COP process, including official side events at COP. And next week, on 20 November, we will host a side event with the Brazilian Bar Association and the American Bar Association, exploring how the legal profession can support climate mitigation and adaptation efforts. So if you are interested in learning about the IBA, please do reach out to me, and I'm happy to give you more information. Third, and lastly, of course, for our participants joining today from Africa and the Middle East, it might interest you to know that the next annual conference of the Association of Environmental Law Lecturers in Middle East and North African Universities, ASELMU, we hold from February 9 to 10, 2026 at Sorbonne University, Abu Dhabi. Selected papers will be published in Africa's leading sustainability journal, the Journal of Sustainable Development Law and Policy, which I lead. So please visit the ASELMU website to learn more about how you can participate. Excellencies, ladies and gentlemen, I do hope today's conference will further deepen systemic solidarity and multi-stakeholder collaboration needed to advance climate action worldwide. I thank you very much.
Thank you very much as well, Professor Dami. It has been an honor and a pleasure to collaborate with you in so many of these crucial roles. And we deeply appreciate also all of the time you have saved us by being willing to carry the flag for so many of our partners, which allows us to turn to our next speaker, Professor Rashad.
Hello, can you hear me?
We can, Professor Rashad. Please continue.
Yes.
Oh. Hello, do you hear me? Okay, great. Thank you, everyone. It's my pleasure to see old friends and new colleagues here in this lovely opening ceremony. I would like to particularly thank to Professor Cordonier, Segger, and Professor Gehring and other colleagues for inviting me to say a few words. and I would like to wish a very good day and successful event for the new host, COP 30. As a dean, I'd like to highlight on a few, let's say, development that have happened in Azerbaijan, but also within the universities, particularly at ADA University, where I'm representing at the moment. The COP29, I think the biggest implication of COP29 was that it revitalized the discourse on environmental law and climate law and sustainable development, not only in Azerbaijan, but in the former Soviet space, I would say. Before in public discussions or policy considerations or lawmaking procedures, maybe it was not very often to hear those concerns or considerations related to climate law or environmental law. But now I often see that in all these discussions, be it in an institutional context or in an academic event, you've got a lot of comments, concerns, or questions related to climate law or environmental law or sustainable development. So I think this is the most important contribution of COP29, that you brought those kinds of issues into the mindset of people, but mostly for young lawyers and policymakers. So I think this is for me one of the most important developments for COP29. Obviously, we were very glad for being a partner to host last year's CLGD and training course. I was very happy, first of all, to meet new colleagues from different countries, but also to see how they have been very enthusiastic on these issues, but also committed to organize these kinds of events. I was very thrilled to see that. I always give the examples how this team was committed for this event to my colleagues here at ADA University. So I think in this context we were very lucky, and again I would like to thank to my colleagues for choosing us to be a partner for this event. So the second point, in particularly in the context of CLDG and the training course.
Second and final point, yes.
I think Bar Association of Azerbaijan, it had great implications. So they established now a new unit on climate law and environmental law related cases. And for ADA Law School, we have proposed new courses for our curriculum, and these courses will be directly related to climate law and environmental law. So we will have a new courses from the next year, and we partner an arbitration simulation on the use of natural resource and responsible investment for law students a couple of months ago. And this year, together with ADA Law Society, ADA Law School is organizing first time ever national moot court competition on maritime law. Thank you so much. I wish you all the best in your endeavors and projects.
Thank you so much. And thank you again for all of your contributions last year as well in your beautiful law faculty with those lovely cedar trees overlooking the water just around the corner from the COP29, where indeed some historic decisions were certainly taken, hard-won historic decisions. I will now turn to our final speaker for just 3 minutes to be able to give us a few ideas, a taste of the conference, the excellent conference that FGV Law organized over the last 3 days in Rio as part of the COP30 hosting efforts. Please, Professor Paula, the floor is yours.
Can you hear me?
Yes, we can. Thank you.
Okay, perfect. So good morning, everyone. It is a truly honor to be here with you today. I want to begin by thanking Professor Marie-Claire for inviting me to give this speech for Climate Law and Governance Day 2025. This initiative represents not only an academic effort, but also a collective call to action. Environmental lawyers, scholars, and practitioners must come together and take concrete steps. Every year we witnesses the consequences of climate change more clearly. So the challenges we face are not simply important to deal with, they are urgent. And that's why this event is so important. We have here today specialists from across the globe representing both public and private institutions, and their presence shows the global dimension of the conversation and the shared responsibility that we all carry. So on behalf of FGV and FGV Real Law, I would like to thank Professor Marie-Claire again, and also Professor Marcus Gehring, Professor Alessandra Lemon, for their partnership and for making this event possible. I would also like to quick acknowledge the institutions that are joining efforts to bring this event to life: University of Cambridge, University of Caxias do Sul, the Federal University of Pará, the Center for International Sustainable Development Law, the International Law Association, and the Global Voice of the Legal Professors. And I also would like to thank all the speakers that were with us, this week actually, and all the speakers today, and each participant who is joining us. It is through dialogue, knowledge exchange, and the courage to confront difficult questions that we can seek solutions, build partnerships, and strengthen the legal tools we need to address a crisis that unfortunately continues to intensify. As a mother of a 4-year-old boy, these conversations are not abstract to me. They are personal. So the world we are shaping today is the world in which our children will grow, and we have both the responsibility and the opportunity to ensure it is a safer, more just, and a more sustainable one. So I honestly believe that together we can at least try to make our world a better place, not only for us, but for the generations that will follow. So thank you all for being here, and thank you again for the invitation.
Professor Paula, thank you so much as well. And thank you for an absolutely brilliant event that we were deeply honored to be part of over the last few days here in Rio de Janeiro in Brazil. It was truly remarkable the way you were able to convene together with all of your colleagues, Professor Romulo of the Pace University and others, everyone online in 3 cities, including especially the subnational leaders and the state leaders and the bar associations, to talk about the role of law in making the change that is needed. So deeply, deeply honored to have you with us here as well. Indeed, very deepest of thanks to all of our opening speakers for your inspiring interventions. We are extremely grateful to you and to your world-leading organizations helping to address the justice challenge of our century, for your partnership, your gracious guidance, your support, and your engagement as members of the program committee for the entire initiative. I'll just underline that the program committee are also the judges for the Global Leadership Awards and for the student essay competition that we will be resuming next year in the COP that is to come when we meet in person again. So please make your nominations to them now. We shall indeed be hearing from all of those who helped to open this symposium online with us over the course of the day in their various different leading roles. I'd like to especially thank those who have joined us. We have 3,300 plus registrants from 115 countries, and especially those who are with us actually in person in their time zone. There's over 485 people online, and we are very, very happy especially to be leaping into the first substantive session of the day in this regard. I will now give the floor to our brilliant masters of ceremony, Advocate Ayman and Advocate Himanshu, to guide us through the next parts of the day.
Thank you very much indeed to both our chairs and our esteemed speakers for these amazing words of welcome and for leading this grand opening. As you saw and heard, there were small smiles all around, ranging from the firm to the broad and wide. We'll now immediately begin our first high-level plenary session on adjudicating state obligations on climate change with world-leading justices from the International Court of Justice, the International Tribunal on the Law of the Sea, and the Inter-American Court of Human Rights. So indeed, welcome to the high-level plenary. It's the leap, the first substantive leap of the day, as was indicated just moments ago by Marie-Claire, for this important session on climate change, as will, of course, many of the sessions be on today. Without further ado, we are delighted to welcome back, he just gave us the floor, but welcome back Professor Cordonier Segger and Professor Kameri-Mbote as co-chair of this plenary. The floor is back to you. Thank you.
Professor Kameri-Mbote, would you like to start us off as we begin this session?
Yes, thank you, co-chair. Thank you very much for the floor. We gather, as all the speakers have said, at an unprecedented moment of judicial engagement with climate change. As of 2025, as demonstrated in the latest UNEP's climate litigation report, launched only last month, over 3,000 climate-related cases have been filed in 55 national jurisdictions and 24 international or regional courts, tribunals, or quasi-judicial bodies, among which international and regional courts standing out as they are being called upon to interpret climate obligations. Indeed, in 2024 alone, more than 200 new climate cases were filed in the US and across the world. Today, we have the extraordinary privilege of hearing directly from those at the forefront of judicial decision-making on climate, which is inextricably linked to other elements of the three planetary environmental crises: biodiversity loss and rising pollution. Tribunals and courts are not merely resolving disputes. They are providing crucial clarity on the obligations that states, corporations, as well as empowering grassroots movements and mobilizing new constituencies in addressing climate change and securing the rule of law. The conclusion by international and regional courts that the human right to a clean, healthy, and sustainable environment is essential for the enjoyment of other human rights will further support the understanding of the interdependence between human rights and the protection of the environment. Through their decisions, they are helping to define the contours of climate justice, establishing precedents that ripple across jurisdictions, and ensuring that climate commitments are not merely aspirational, but legally enforceable. In this context, it is my great pleasure to turn to Professor Marie-Claire to introduce our esteemed speakers.
Thank you so much, Professor Dr. Patricia. It is a pleasure, of course, to collaborate with you this year and in previous years in order to be able to host such a distinguished and important high-level plenary. We are honored to be joined by world-leading jurists from several of the highest courts of the world to explore, especially, crucial questions such as why are the recent advisory opinions of international tribunals on climate change so important just at this moment in history? And how do they advance understanding of the obligations of states in respect of climate change across the Americas, with the law of the sea, and indeed for our world? First, we are deeply honored to welcome Judge Leonardo Nemer Caldeira Brandt, a distinguished judge of the International Court of Justice. An eminent Brazilian jurist, he brings to the bench of the world's highest court a notable record of public international law scholarship, as well as his experienced leadership as founder of Brazil's Center for International Law, CISDL. Prior to being elected to the ICJ in 2022, Judge Brandt held a long and influential academic career as a tenured professor of public international law at UFMG and at the Pontifical Catholic University of Minas Gerais. Judge Brandt's scholarly work encompasses over 30 books and more than 100 articles in Portuguese, English, and French on topics ranging from human rights and international criminal law to state responsibility and the doctrine of res judicata. We are deeply honored to have him here with us today, truly also on behalf of the presidency and the world that is hosting us today for COP30. Judge Brandt, Your Excellency, the floor is yours.
Thank you very, very much. I'm very honored to be here with you today, and thank you for giving me the floor. And you know, the question are a broad question, and of course we don't have enough time to answer all the scope of the question. But in that case, I would like to concentrate it myself on the consequences of the branch of the law, of the environmental law and climate change law, and the state's responsibility. And in that case, I will start my intervention, well, defining the applicable law that the court defined. So, first, as regard the applicable regime, the court recalled that the determination of state responsibility in climate context is governed by the general law of international responsibility, provided for the customary law and codified in the articles on responsibility of states for international wrongful acts. The court made very clear that in the context of climate change, now I quote, a state which fails to comply with its obligations under international law, including those concerning the protection of the climate system and other parts of the environment, commits an international wrongful act in paragraph 406 of the advisory opinion. So, in practical, the fact that states' responsibilities contained in customary law allows litigants, such as low-lying island states or regional organizations, to rely on the law of responsibility to seek cessation, reparation, even where specific treaty mechanisms are, in that case, silent. So, in this analysis, the court determined how a state incurs responsibility for breaching its climate obligation by examining three elements, namely, of course, attribution of conduct, causation of harm, and the erga omnes character of the underlying obligations. Together, these three elements establish the legal conditions under which a state acts or omissions give rise to international responsibility for climate harm. The court, in matter of attribution, the court addressed how states' conduct is attributable in the context of climate change. It explained that, now I quote, failure of a state to take appropriate action to protect the climate system from GHG emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration license, or the provision of fossil fuel subsidies, may constitute an international wrongful act, which is attributable to that state in paragraph 427. It further clarified that, now I continue to quote, a state may be responsible when, for example, it has failed to exercise due diligence by not taking the necessary regulatory and legislative measures to limit the quantity of emissions caused by private actors under the jurisdiction, paragraph 428. These statements establish that omissions, no less than direct acts, can engage responsibility where a state's failure to regulate it, supervise, or restrict harmful conduct contributes to climate harm. In terms of causation, so then the court turned to the issue of causation. It recognized that causation in the context of the climate change pose a particular challenges given the accumulation and global nature of GHG emissions and their effects. Paragraph 433. However, it determined that, now I quote, a causal link exists between states' failure to comply with its international obligation and the resulting adverse effects of climate change when that fail makes a significant contribution to the harm. 434. It made it clear that a state cannot escape responsibility merely because, and now I quote, its individual contribution or small is small in quantitative terms as long as that contribution is significant when assessed in light of state's capacity level or emissions and knowledge of the risks involved. Paragraph 436. Now I turn to erga omnes obligations. And the court affirmed the erga omnes nature of the climate-related obligations. It held that, now I quote, the obligations concerning the protection of the climate system and other parts of the environment are obligations erga omnes, paragraph 439, and that, I continue to quote, these obligations are owed to the international community as a whole, and all states have a legal interest in their protection. Paragraph 440. As a result, any state may invoke the responsibility of another state for a branch of these obligations, even if it's not especially affected by that branch. Paragraph 441. I think this is the most important part of our advisory opinion, who opened the possibility to litigation. The finding reflects the universal character of climate protection, confirming that the duty to salvaguard the climate system protects a collective interest shared by all humanity. So, if I have time, may I continue? I still have a little time.
Yes, please. 2 more minutes. So please, you are very well timed.
So I would like to turn to the legal consequences arising from wrongful acts. In the final stage of the analysis of the state's responsibility regime, the court developed the consequences arising from the state failure to comply with their international obligations relating to the protection of the climate system by examining their continued duty to perform their international obligations in good faith. This is the first point. The duty of cessation and guarantees of non-repetition to prevent future breaches. This is the second point. And their duty to make reparations for harm already caused. I would like to have a little more time to develop one of each of those points, but I think I don't have it. But in any case, I suggest that we can go to the advisory opinion. And it's a very progressive advisory opinion, and I'm very proud to be part of that. And the court will define all the legal issues and clarify the legal issues concerning the climate change protections. And I think it's opened the possibility for new litigations in the national level and in the international level as well. So I thank you very, very much for the opportunity and the honor to raise those questions here and to be invited for this very important meeting. Thank you very much.
Thank you very much, Judge Brandt, for those very insightful remarks. We are delighted now to hear from Judge Kathy Ann Brown, renowned judge of the International Tribunal for the Law of the Sea, a leading voice on global dispute resolution and maritime law. She has served as permanent representative of Jamaica to the International Seabed Authority and also as Chief Technical Advisor to the Prime Minister and Deputy Solicitor General, International Affairs in the Attorney General's Chambers of Jamaica, and is a laureate of the Wiramantu International Justice Award. As counsel in highly significant disputes before the Caribbean Court of Justice and the World Trade Organization, WTO, and as a panelist in WTO disputes, she is an extremely eminent jurist as well and holds multiple teaching and advisory positions across the West Indies, Guyana, London, Brussels, and Geneva. Judge Kathy Brown, you have the floor.
Thank you so much for that gracious introduction, Professor. You ask, why are the recent advisory opinions of international tribunals on climate change important? There is an implementation deficit fueling the ecological crisis, of which climate change is a leading cause, altering marine, terrestrial, and freshwater ecosystems through rising temperatures, ocean acidification, and more extreme weather events. Hurricane Melissa was one of the most intense Atlantic hurricanes on record, the most powerful hurricane to hit Jamaica in recorded history. The ITLAS advisory opinion on climate change was drafted to be understood by a broad set of interested stakeholders. Obligations pertaining to the protection of the climate system and marine environment from anthropogenic GHG emissions are obligations erga omnes. That is to say, in view of the importance of the rights involved, all states, indeed all people, can be held to have a legal interest in their protection. The three climate change advisory opinions have been featured in the news because they address critical issues of ocean and planetary health, requiring an urgent response. Climate change is a collective problem requiring a collective response. The requests for advisory opinions represent a collective call to address the implementation deficit. Contentious proceedings are limited to a specific set of facts that occurred in the past, generally in the context of a bilateral dispute. Advisory proceedings are consultative and prospective. They are designed to provide guidance for future conduct based on the current state of the law, the lex lata. They explain the ground rules for the initiation of new steps in a process that may lead to the progressive development of international law. The conclusions made in advisory proceedings complement and facilitate, but do not replace, other procedures for the peaceful settlement of disputes, such as the ongoing negotiations at COP30. How do the advisory opinions advance understandings of the obligations of states in respect of climate change? 6 points, briefly. 1, both the ITLAS and ICJ opinions are unanimous. This lends weight and legitimacy to their pronouncements. Judge Taladi of the ICJ expressed views on this issue, which I share. He observes that, and I quote, the magnitude of the climate change crisis demanded at least 2 things in rendering this advisory opinion. First, it demanded a unified court, rendering its reply with the unanimous support of all judges, a rarity in the history of the court's advisory jurisprudence. Second, it demanded that the unity of the court not be achieved at the expense of the robustness of the opinion. To meet this dual demand was always going to be challenging, but I'm pleased to say that in this case, the court has largely risen to the challenge. The request for advisory opinions of both ITLAS and the ICJ sought clarity on states' obligations in protecting our oceans from the negative effects of climate change. Both courts have spoken in unison and unanimously. That cannot be ignored. 2, the most consequential finding of the ITLAS opinion is that anthropogenic GHG emissions are pollution of the marine environment, as that term is defined in the UN Convention of the Law of the Sea, referred to as UNCLOS. The uncontradicted scientific evidence presented to the tribunal was that GHGs are introduced by humans directly and indirectly into the ocean, and are the cause of and are likely to result in further harmful effects. Because of its solubility and chemical reactivity, carbon dioxide from human activities is taken up by the ocean much more effectively than other emitted gases. GHGs also trap heat within the atmosphere, and the ocean then stores this heat. The result is ocean warming, sea level rise, and ocean acidification. 3, UNCLOS obligations in relation to the prevention, reduction, and control of pollution of the marine environment apply to all activities, giving rise to GHGs, as UNCLOS applies to pollution from any source, whether land-based, vessel-based, or from or through the atmosphere. Although the nature of the disciplines varies depending on the source, they may call for specific measures, such as the enactment and enforcement of laws and regulations, or the undertaking of monitoring and assessment. These measures are context-specific and call for objectively reasonable approaches to be taken on the basis of the best available evidence. Now, science. The ICJ advisory opinion adds a measure of specificity to this. You just heard from Judge Brandt that the opinion states failure of a state to take appropriate action to protect the climate system from GHG emissions, including through fossil fuel production, fossil fuel consumption, and the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies, may constitute an internationally wrongful act, which is attributable to that state, end quote. A little less than 40% of global oil production and 30% of global natural gas production comes from the offshore industry. The ICJ pronouncements are therefore of particular significance in understanding the implications of states' obligations under UNCLOS as they are addressed in the ITLAS advisory opinion. The recent 28 October 2025 decision of the European Court of Human Rights in Greenpeace Nordic and others against Norway concerns offshore petroleum activities and cites the 2024 ITLAS and 2025 Inter-American Court on Human Rights, ICJ, and the EFTA Court advisory opinions in attaching great importance to the procedural obligations requiring a comprehensive EIA of petroleum production effects on the climate, including the global effects of combustion emissions before a plan for development and operation is approved. 4, the 3 climate change advisory opinions reinforce the coherence of the international legal order. The ITLAS opinion emphasized that while the Paris Agreement complements UNCLOS in relation to the obligation to regulate marine pollution from anthropogenic GHG emissions, the former does not supersede the latter. They are separate agreements with separate sets of obligations. Nevertheless, it is a generally recognized principle that when several rules bear on a single issue, they should, to the extent possible, be interpreted so as to give rise to a single set of obligations. Similarly, the ICJ stated that it considers that UNCLOS, the climate change treaties, and other relevant environmental treaties, as well as the relevant obligations under customary international law, inform each other. States parties must therefore take their obligations under UNCLOS into account when implementing their obligations under the climate change treaties and other relevant environmental treaties and under customary international law, and vice versa. The converse equally applies. The UNFCCC COP25 initiated the Ocean and Climate Change Dialogue. Previously, little attention was paid to the health of the oceans in climate negotiations. The 2025 NDC Synthesis Report notes that of the 26 countries that had submitted NDCs by 30 September 2025, there is a significant increase in ocean-based climate action compared with the previous NDCs. However, a significant proportion are conditional commitments tied to finance-related needs for ocean-based action. The ICLAS opinion identifies mechanisms under UNCLOS that are designed to assist developing states in appropriately addressing marine pollution, including pollution from anthropogenic GHG emissions. These mechanisms coexist with those indicated by the UNFCCC and the Paris Agreement for supporting capacity building, technical development and transfer, and the financial capabilities of developing states. 5, while the precautionary approach is not explicitly referred to in UNCLOS, such approach is implicit in the very notion of pollution of the marine environment, which encompasses potential deleterious effects. The ICLAS opinion underscores that in determining necessary measures to regulate marine pollution from anthropogenic GHGs, scientific certainty is not required. In the absence of such certainty, states must apply the precautionary approach. This requires that in implementing measures, states take into account the best available science and relevant international rules and standards, such as contained in the UNFCCC and the Paris Agreement, in particular the global temperature goal of limiting the temperature increase to 1.5 degrees Celsius above pre-industrial levels, and the timeline for emission pathways to achieve that goal. Finally, 6, the obligation to take mitigation and adaptation measures is one of due diligence, and the standard of due diligence is stringent, given the high risk of serious and irreversible harm to the marine environment from GHG emissions. The obligation of due diligence is closely linked with the precautionary approach. Therefore, states would not meet their obligation of due diligence if they disregarded or did not adequately account for the risks involved in their activities under their jurisdiction or control. Ultimately, the effectiveness of these advisory opinions will depend on how they are given life through the COP and other negotiating bodies, including the IMO, through the courts, such as the recent European Court on Human Rights Greenpeace Nordic decision, or through domestic legislation, policymakers, making and transnational advocacy. Their importance depends on how you use them in ensuring accountability, empowering vulnerable communities, and safeguarding ocean and planetary health. Thank you very much for this opportunity to share my views.
Thank you, Judge Kathy Ann Brown. You are, as always, brilliant in pointing out what is truly the essence of our international legal obligations. And as we hear, as an entire global law and governance community, this is indeed a challenge for us all to use your judgments that you have worked so incredibly hard and with such vision and inspiration to deliver to us all, especially as an esteemed and highly distinguished legal scholar in your own right, and of course, Deputy Solicitor General of a small island state that will be so deeply impacted, is being so deeply impacted by climate change. We owe it to all of you and to our world to take up the challenge that you and Judge Leonardo and others have put in front of us. And we take this extremely seriously. We are now delighted to hear from Judge Patricia Perez Goldberg of the Inter-American Court of Human Rights. She holds an excellent PhD in law from the University of Valparaiso, truly one of the most beautiful cities in the world, and also very coastal and very vulnerable. And she is also an honorary doctorate holder, like others, probably not her last one, from the University California Western School of Law. Former Minister of Justice and Public Defender of Chile, she has pioneered gender-based prison policy and authored world-leading works on women's rights, indigenous childhood, and the capabilities approach, an interest that I share. And her distinguished honors and leadership within the Inter-American human rights system highlight her concern for legal rigor in their recent advisory opinion and her exceptional service over many years on the court. Now, for those who are differently abled who are joining us today, I will say that Patricia and I, Professor Patricia Kameri-Mbote and I, are sitting here with, in my case, long blonde hair and a brightly colored green and blue jacket and an ancient Cambridge Law Library behind me. And in Patricia's case, the United Nations Environment Programme office is in Nairobi behind her. She has dark glasses, dark rimmed glasses, beautiful dark short hair, and gorgeous golden necklace of Africa that she is wearing, and a dove gray jacket, and a lovely look of both determination and kindness on her face. We are also joined, of course, by Judge Leonardo and Judge Caxias. Judge Leonardo is in an extremely distinguished suit, and he looks extremely firm, but also kind in his judicial esteem that he has joined us with today, while we have Judge Caxias in a lovely dark black, maybe velvet dress, and very short hair and lovely glasses and a wide smile, joining us from, I think, Jamaica this morning. Judge Patricia Perez, of course, is beautiful with long dark hair, a wide smile, the Inter-American human rights system in the background from her corte, and a black dress. And she is smiling with us today and about to give her address. Judge Patricia, the floor is yours.
Thank you so much. Good morning, good afternoon, good evening to everyone. Thank you. And my warmest congratulations to Professor Cordonier and the entire team for the organization of this important event. It is truly a great honor to take part of this dialogue today. In my remarks, I will address 4 dimensions of the Inter-American Court's advisory opinion on climate emergency and human rights. First, I will outline some of the common threads that connect the 3 opinions regarding climate change that have been recently delivered. Secondly, I will offer some background on the Inter-American advisory opinion itself. Thirdly, I will turn to the core of that opinion, which lies in the recognition of intergenerational justice. Fourthly, I will briefly highlight 2 of the points on which I express my dissenting view. Finally, I will conclude with a few reflections on the broader meaning of intergenerational justice. Although the 3 advisory opinions were issued by different courts, they converge on 2 essential issues that mark a new phase in the application and development of international law. First, all 3 clearly underscore that the Paris Agreement established binding legal obligations and not mere recommendations or expressions of political will. States are legally bound to act with due diligence in adopting science-based mitigation measures to prevent foreseeable harm to the climate system. The standard of due diligence required of states is stringent. This recognition has important domestic implications. National courts can and should rely on these interpretations when applying the Paris Agreement and other environmental and human rights norms, ensuring that climate commitments are implemented as enforceable legal duties. Second, the opinions reaffirm the duty to prevent significant harm to the climate system under customary international law, extending it beyond the transboundary sphere. Thus, this duty is no longer confined to harm between states, but applies to the climate system as a whole, acknowledging that all states share responsibility for preserving the planetary conditions that make human life possible. If a state does not comply with its treaty or customary obligations, it will incur an international responsibility and may, in some circumstances, owe reparations. The Inter-American opinion in context. Our advisory opinion was requested by Chile and Colombia, and the process that followed was unprecedented in scale and inclusiveness. The court received 263 written observations from 613 actors, including 18 states, UN agencies, regional organizations, universities, NGOs, private entities, and individuals. 3 public hearings were held in Bridgetown, Brasilia, and Manaus. More than 100 oral interventions were presenting, bringing together indigenous and Afro-descendant communities, women and youth organizations, and scientific experts from across the region. The court held that the current scenario could be considered a climate emergency because of the conjunction and interrelation between 3 factors. 1, the urgency of taking effective measures to confront the climate emergency, the seriousness of its impacts, and the complexity of the responses required by states. It was the most participatory advisory process in the court history. The core of the opinion, intergenerational justice. At the very center of this advisory opinion lies the principle of intergenerational justice. This principle affirms that the protection of human rights must extend across time, from the present generation to those who will live with the long-term consequences of our decisions. It demands that the states act with foresight, prudence, and responsibility, preventing irreversible harm and preserving the environmental conditions that sustain life and dignity. Intergenerational justice thus transformed the idea of human rights protection as one that extends across time. It reframes the obligation of states not only as negative obligations of prohibition against harm, but also as positive duties of preservation, prevention, and solidarity. This vision also broadens the notion of equality. Justice must be achieved not only among contemporaries, but between those who exist and those who are yet to come. It recognizes that climate injustice is not only spatial between North and South, but also temporal between the living and the unborn. Environmental protection, therefore, becomes a precondition for both the realization and the fulfillment of all human rights. Regarding my dissented opinion, while I share absolutely the ethical and humanistic foundations of the advisory opinion, I raise several concerns in my separate opinion. Today, I will highlight two of them as they directly relate to the structure and legitimacy of international law, the classification of certain environmental obligations as yes cogents, and the recognition of nature as a subject of rights. My first reservation concerns the conclusion that the prohibition of causing severe and irreversible environmental harm has already acquired the status of a peremptory norm of international law. In my assessment, that conclusion does not yet satisfy the established criteria of international law. For a rule to attain a yes cogent status, it must be accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted. At this stage, such a universal consensus is not sufficiently evidenced with respect to environmental obligations. I have no doubt that this obligation exists under customary international law. The imperative to protect the environment is beyond question. However, its elevation to the rank of yes cogents without the necessary degree of state acceptance may weaken rather than strengthen the normative coherence of the international system. Furthermore, if international courts are willing to declare that a rule has a yes cogent status without the necessary rigor, it may prompt states to react preventively against the crystallization of such rules. As judges, our responsibility is to ensure that normative evolution proceeds on solid legal foundations and not through aspiration alone. My second reservation concerns the recognition of nature as a rights holder. The idea carries great moral and symbolic value. It challenges anthropocentrism and invites us to rethink the relationship with the natural world. However, the inter-American system of human rights remains based on human dignity as the primary source of rights and obligations, as enshrined in the American Convention of Human Rights. Extending legal personality to non-human entities would require a structural transformation in our order, one that cannot arise solely from judicial interpretation, in my view. Such a shift must emerge through state consent expressed in treaties, constitutional processes, or consistent international practice. Otherwise, even the noblest aims risk undermining the legitimacy and authority of international adjudication. About the deeper meaning of international justice is not just peripheral. It is the moral foundation of contemporary human rights law. It asks us to look beyond immediate interests and to recognize our shared responsibility to those who will inherit the planet. Every judicial decision has a temporal dimension. It responds to the present while shaping the future. In this sense, law becomes a bridge between generations. The international Court of Justice has affirmed that intergenerational equity is a guiding principle for interpreting states' obligations under climate treaties and customary international law. Climate science, therefore, is not external to legal reason. It forms its factual and ethical core. A state that disregards scientific evidence does not merely act imprudently, it fails to exercise due diligence and breaches its responsibility to the future. Intergenerational justice also reaffirms accountability. It requires not only addressing past harm, but preventing foreseeable future damage and ensure the conditions in which human life can flourish. Seen through this lens, care becomes a legal principle. The state's duty is not only to avoid harm, but to sustain the conditions of life itself. This idea can be related to the capabilities approach, which conceives justice in terms of the real freedoms that enable both present and future generations to lead lives they have reason to value. This advisory I'm just concluding with this. This advisory opinion stands as a milestone in the convergence of human rights and environmental protections in the Americas. Together with the opinions of the Law of the Sea Tribunal and the International Court of Justice, it forms part of an emergent jurisprudence of care, solidarity, and shared responsibility across generations. For courts and judges everywhere, the message is clear. Protecting the environment is inseparable from protecting humanity itself. Yet our interpretative ambition must remain anchored in the discipline of law. The legitimacy of our institutions depends on our ability to combine empathy with precision and vision with restraint. Intergenerational justice calls on us to expand the temporal horizon of law so that those who come after us inherit not only a planet capable of sustaining life, but also a legal order worthy of their trust. Thank you very much.
Thank you very much, Judge Patricia, and especially for your defense of future generations. I can imagine that you were indeed, and I have heard from my colleagues the same, a truly awe-inspiring Minister of Justice and jurist for your country. Thank you so much indeed, distinguished justices, for all of your remarks. You have been extremely provoking, thought-provoking, but also provoking. And the challenges that you have laid in front of us are going to shape our work and the work of over 530 people online, as well as more than 3,000 who will be listening afterward in the years to come. Because you have been so restrained as well, we are able to take one round of questions from our audience, and I'm so pleased that is possible. I understand that we can turn to our online moderators, Advocate Tejas, Advocate Christian, and Advocate Reyla from India, Colombia, and the Philippines, respectively, who are here with us online, if we can see them on the screen, to give us a few more of the burning questions posed by those joining us from all over the world. And I will ask also if Professor Alessandra and Professor Marcos, as chairs of the day, could also join us online for the questions. And I will turn to our online moderators so that they can to give us a few of the questions that have come up online. I'm also encouraging anyone who is listening and would like to be putting forward a question to our esteemed judges, if you would please put your name, your country, and if you are affiliated with a particular university or organization in your question. Thank you. Advocate Tejas, Advocate Christian, Advocate Reyla. What is our first set of 3 questions by whom?
Hello, so we have a few questions relating to adaptation and how it is best streamlined to national law. So the first one is aligning national laws with Paris Agreement obligations, considering that scientific evidence shows that current development models still generate unsustainable pollution or emission levels. Another one on most effective legislative frameworks and best practices on agriculture, water resources, and infrastructure. And then last, on how the global goal on adaptation can help with this and how we can further the conversation on adaptation. Another question is on obligations of states relating to ensuring effective readiness of poor and low socioeconomic groups. Over to our speakers.
Thank you, Advocate Rayla. Please could you tell us from whom those questions come, in which countries, if that is all right? I see that they are representing several questions.
Yes, so we have questions from Xi'an, China. We have one from Morocco and one from Egypt. Those are the questions on adaptation. And then the other one did not mention where he's from, unfortunately.
Thank you very much. I see more questions are pouring in. I will just turn to Advocate Tejas or Advocate Christian, since we will only have one round of questions. If you would like to share maybe one more topic that is being raised online and from whom it comes, especially if 2 or 3 of them agree.
Yeah, absolutely, Professor Cordonier Segger. Very happy to help with that. We have a very interesting question from Alison Chacharian from the United States of America, Tesfaye Abate from the EPUE School of Law, as well as Chipwe Mumba from Zambia. And all 3 of them have actually asked, how can these critical advisory opinions best be incorporated into the UNFCCC multilateral process and into international law? So we would pose that question. Christian, would you like to come in with one further? Professor Cordonier Segger, maybe over to you.
Sure. So we have 3 questions asked by 9 people so far, and I will come back to our judges in their order of appearance. One is in relation to obligations of states, but for adaptation, and whether you have thoughts on this. I understand that Judge Kathy Ann Brown, you referred to this briefly in some of your remarks. So perhaps you may wish to take that one, but certainly either judge may jump in on it as well. The second is on ensuring that the obligations of states more generally are made clear and respected, and that call for action, which echoes indeed the comment that all 3 of you made. And then the third one concerns the incorporation of the international law that was identified in these judgments into multilateral COP processes, including the one in which we live today. So I would invite you, if you wish, to address any of these 3, and I will start with an esteemed scholar of public international law, as well as ICJ Judge Leonardo Brandt. And Judge Brandt, you actually spoke in Cambridge nearly 6 or 7 months ago on some of these issues, and we would welcome any of your thoughts that you wish to share with us. You certainly impressed our students.
Yes, I do. Yeah. So thank you for those questions. And well, I think that we can answer, we can reply that in a unique way. The role of the court is to clarify in terms of advisory opinion. Of course, an advisory opinion is a non-binding decision. It's an opinion. It can be received as binding, but well, in Article 96, well, we all know that there is no binding opinion. So the importance of the advisory opinion is to interpret it, is to clarify points, is to say where the law lies. So what we are doing is trying to clarify the law. And this is very important. When you say that law must incorporate science, for example, when you say that we have a guarantee, we need to guarantee the intergenerational protection on climate change, when you see the substantive laws concerning adaptation, mitigation, or reparation, or cessation, or the consequences of a breach. So we are interpreting the law. We are, clarifying what the protection of climate change means. I mean, the protection of climate means. So in that term, it's not our job as a judge from, I mean, in terms of advisory opinion, as a judge, to say how adaptation must take form in a particular case, or how it, well, we will get those rules, those norms in the national sphere of law. So what's going on now is that the civil society and the attorneys from national groups or international states, I mean, they need to go to the judiciary, and they base it on our clarification. They need to go to press for the incorporation. And the incorporation will be done by negotiation or by jurisprudence or by legislative norm. So that's it. Our role is, as I said, to clarify, to create a framework, and then is for the civil society, for the ONGs, for states, for international specialized institutions to take over. I mean, and go further. And that's my point. Because, I mean, we are not able to do that. As you know, the court only reply, well, a direct question posed by, well, made by the General Assembly. So we are close in that framework. That's why. Thank you very much.
Absolutely. When we are teaching our students, we often say people are asking whether the advisory opinion is binding in the same way that you would ask whether the outside of a glass full of very powerful water is wet. The point of glass is that it is full of water. It is not that it doesn't tell us what it is we actually need to know, which is what is the binding law, and then we interpret it, as is our job. I will also call all students online your attention to the final paragraph of that incredibly moving judgment, because I think it speaks very well to the processes of change that are required for survival, and the importance of these issues. I will turn now to Judge Kathy Ann Brown and Judge Patricia Perez to answer any of the other elements of the question that you wish.
Well, thank you, Prof. Marie-Claire. You mentioned the issue of adaptation, and actually, I would say that after the ITLAS advisory opinion, I was very heartened to see where we had made the point about the migration of fish and the impact that this was having on particularly states where they were dependent on their fishery resources, particularly if you look like in the Pacific. And when the fish migrate, it impacts on how much they net, how much they catch, and for those in the Pacific, their licenses that they can hand out. And we said that RFMOs, that's regional fishery management organizations, should take into account the impacts of climate change in developing their management practices. And I saw after the opinion that we saw a decision of an RFMO, I can't remember which one, but that they were they cited the opinion and said that this is something that they needed to do, and that's adaptation. You know, you can mitigate climate change, but we've gone so far that you're not going to stop it. So you have to learn to deal with it. And when you think of adaptation, and questions refer to legislation, it's not just legislation. The implementation deficit is not just because states haven't legislated. It's policy and they don't implement it. So, for example, in the ITLAS advisory opinion, we speak about the importance of mangroves and how you can have sea defenses. That's a policy. That's a policy that needs to be implemented into how you take care of your waterfront. So adaptation is there, but also the legislation. For some areas, legislation is important. The reason why the opinions are important is that what they're saying is that these obligations already exist. the obligations are binding on states. It is for states now to implement them, and they haven't. So this is the import, and this is the importance of these advisory decisions, because they're telling you this is what you already have obligated to do. What you're doing in COP now is negotiating where you go forward. What else do you need to do? Or why aren't you implementing what you have already committed to do? And I think that this is the emphasis. And so adaptation is very important, because we talk a lot about mitigation, and I mentioned the fuel issue myself about, fossil fuels, but that's not the only problem. It's also how we adapt while we seek to continue to mitigate. Thank you.
Absolutely. And indeed, in the COP, we need to be talking about who will help us and work together with us and form partnerships and collaborate. That duty to cooperate that all three of these judgments have emphasized again and again is something that in the COP can be realized, whether it is through groups of countries coming together or whether it is through the unusual consortia and partnerships that we form. But not to do it, I think, would be a grave error. I will turn to Patricia, Judge Patricia, if you would like to just give a few thoughts.
Yes, America, thank you. Just to add to what my distinguished colleagues have said, I would think that one real crucial thing that states have to do is to align their budget planning, to the reality of the climate emergency, because otherwise they're not going to be fulfilling the commitment to act with due diligence. So this has to consider science-based findings, the needs of the vulnerable people, everything has to be considered in the budget planning, in the national budget planning that every year every state has to do. So I think that's very crucial for in the light of the due diligence they have to with the due diligence they have to act. And secondly, if I may, I just wanted to add that it's one thing that I think it's very important regarding adaptation is personal choices, because our emergency situation regarding climate is not only due to the lack of the fulfillment of state obligations or the responsibility of corporations, but of our daily decisions, millions of decisions. Just an example, fast fashion. Every decision we as human beings are making every day has an impact in the climate situation. So I would remember, every one of us, how are we contributing to the betterment of our world, or how are we really not contributing to improve things? So that's it. Thank you.
Thank you so much, distinguished judges, professors, and colleagues, for such insightful reflections. What we have heard today affirms that international and regional courts are not only arbiters of disputes, but contributors to a new era of environmental rule of law. Through the advisory opinions of the International Court of Justice, the International Tribunal for the Law of the Sea, and the Inter-American Court of Human Rights that the judges have so ably shed light on, we are witnessing the crystallization of legal principles that translate international moral imperatives into binding state obligations. These opinions identify and illuminate the responsibilities of states to prevent harm, protect vulnerable peoples and ecosystems, and cooperate in the face of a shared planetary environmental crisis. They also demonstrate that the judiciary is emerging as a guardian of intergenerational equity, ensuring that commitments to climate action are credible, just, and forward-looking, even addressing issues of future generations. As we conclude, let us carry forward the inspiration of this plenary to strengthen legal reasoning, institutional capacity, and judicial courage, so that climate justice may be realized across the world. The law, when grounded in science, and I would add credible science, equity, and humanity, remains our most powerful instrument for hope and transformation. Professor Marie-Claire, it has been an honor to chair this highly eminent plenary with you, as it always is. And it is now a pleasure to give the floor back to our Masters of Ceremonies, Ayman and Himanshu.
Deepest of thanks.
Thank you very
To all of our distinguished speakers who've joined us in this grand opening and high-level plenary. We are truly grateful to all of you, and especially to Professor Patricia as well, and to our chairs, Professor Marcus, Professor Alessandra, and the others who have made it possible. We are looking forward to continuing to grow this inspiring global and crucially important circle of law and public policy leadership worldwide. We are especially pleased that it will be possible to move forward in the day with these insights, and indeed move forward in our work as jurists, guided by the remarkable advisory opinions that we have all discussed today. I commend you all, and with warmest of thanks to the plenary and partners and keynote